Welcome to this explainer. Today, we're unpacking a truly landmark decision from the Constitutional Court of South Africa. This case perfectly illustrates the incredibly delicate and honestly often volatile balance between two absolutely fundamental democratic rights, the freedom of the press and the protection of human dignity. We're going to look at exactly how the law navigates this tightrope using some pretty brilliant structural compromises.
But hey, before we get into the heavy constitutional theory, picture this for a second. Imagine waking up on a Sunday morning, grabbing your coffee, and opening the local newspaper, only to find your name plastered across the front page, accusing you of being a criminal mastermind. If you decided to sue that newspaper to clear your good name, who do you think should carry the burden of proof in court? Like, do you have to prove you're innocent? Or does the newspaper have to prove their explosive claims are actually true? Keep that legal dilemma in the back of your mind as we go.
Okay, let's dive into this. Here is our roadmap. First, the bank robber politician. 2, anatomy of defamation. 3, free speech versus dignity. 4, the zero-sum game. 5, the reasonable publication defense. And 6, the final verdict. Section 1, the bank robber politician, the inciting incident.
Our story kicks off with Bantu Banke Harrington Halamisa. He's a well-known South African politician and the leader of a political party. Now, a newspaper called The Sunday World published a deeply damaging article about him. The writers, including a journalist named Fred Kumalo, stated flat out that Halamisa was involved with a gang of bank robbers and that he was actively under police investigation for it. Naturally, Halamisa didn't just take this lying down. He sued the publishers of The Sunday World for defamation. In response, the newspaper essentially raised a major legal objection. They argued that because Halamisa was a politician and the story was a matter of high public interest, his lawsuit shouldn't even be allowed to proceed unless he explicitly claimed the article was false.
Moving on to Section 2, anatomy of defamation, unpacking the common law delict. Under South African common law, which actually stretches all the way back to the Roman law actio injurium, a plaintiff claiming defamation has to tick off 5 distinct boxes. There must be 1, a wrongful act. 2, it must be intentional. 3, there must be publication. 4, the statement itself must be defamatory. And 5, it has to be concerning the plaintiff. Now, once the plaintiff proves that a defamatory statement about them was published, the law actually just presumes that the publication was both wrongful and intentional. The burden then totally shifts to the defendant to prove otherwise. Now, what's really interesting here is what is completely missing from that 5-step checklist. Did you catch it? It's falsity. Under the traditional common law of defamation, the plaintiff, so Halamisa in this case, does not actually have to allege or prove that the defamatory statement is false. The newspaper argued that this omission was unconstitutional. They basically said, look, if the media is sued over a matter of public interest, the politician should be the one forced to prove the statement is a lie. Section 3, free speech versus dignity, the constitutional clash. And this brilliantly illustrates our core conflict. On one hand, we have Section 16 of the Constitution, freedom of expression, which explicitly protects freedom of the press and the media. But weighing against that, we have human dignity. And, human dignity isn't just some side note in South Africa. It is a foundational, bedrock constitutional value. The law of defamation sits exactly at the volatile intersection of these two heavyweight rights. Let's look a little closer at the media's side of things first. The judgment highlights the undeniable importance of the mass media in any democratic society. I absolutely love this quote referenced in the court's decision. It is the function of the press to ferret out corruption, dishonesty, and graft wherever it may occur. It must advance the communication between the governed and those who govern. Right? If the media are scrupulous and reliable, they literally invigorate a fledgling democracy. They're the primary agents keeping a government open, responsive, and accountable to us. But then, right on the other side of the scale, we have dignity. Justice O'Regan points out that freedom of expression, while incredibly fundamental, is not a paramount value that just eclipses all others. Listen to this powerful quote from the court regarding dignity. The Constitution asserts dignity to contradict our past in which human dignity for Black South Africans was routinely and cruelly denied. Dignity is about a person's intrinsic worth, and a massive part of that worth is their reputation. You simply can't have a functional society where an individual's good name is subjected to unjustified savaging without any legal remedy. Section 4. The zero-sum game. The burden of proof dilemma. To really grasp the media's argument, we have to talk about a concept called the chilling effect. Sometimes, journalists know a story is true. They've heard the whispers, they've spoken to off-the-record sources, but bringing admissible evidence into a court of law to prove absolute truth, that is incredibly difficult. Documents go missing, eyewitnesses suddenly refuse to testify. If the law says a newspaper is liable for massive damages unless they can definitively prove in a courtroom that their story is 100% true, well, editors might simply stop publishing public interest stories entirely out of fear of bankruptcy. That fear, that insidious self-censorship, is the chilling effect. All of this builds into what Justice O'Regan described as a zero-sum game. It's basically an unwinnable situation if you look at it strictly in black and white. If you force politicians to prove a statement is false, which, remember, is exactly what the Sunday World newspaper wanted, politicians could have their lives completely ruined by unprovable gossip. I mean, how do you mathematically prove you didn't have a secret meeting in a dark alley 5 years ago? It's practically impossible. But on the flip side, if the media must definitively guarantee the absolute truth of every single fact before printing, we get that massive chilling effect on journalism. If the burden of proof shifts entirely to one side, the other side's constitutional right is heavily, heavily compromised. Section 5. The reasonable publication defense. The Bogoshi precedent. To truly appreciate this defense, let's take a quick look at a timeline. Prior to 1998, the media faced what we call strict liability. If they published a false statement, they were liable, period. End of story. But in 1998, a groundbreaking case called Bogoshi went up to the Supreme Court of Appeal. The court realized strict liability totally failed to recognize the importance of the free flow of information. So they carved out a brand new fourth defense, reasonable publication. And in 2002, with our current case of Kumala v. Halamisa, the Constitutional Court was tasked with deciding if this new balance was actually constitutional. So the absolutely crucial point is captured right here in the Bogoshi precedent. The court stated, quote, "The publication in the press of false, defamatory allegations of fact will not be regarded as unlawful if it is found to have been reasonable to publish the particular facts in the particular way and at the particular time." This is a game changer. It means a journalist can publish something that turns out to be factually false and still not be sued successfully, provided they made an honest, careful mistake. But make no mistake here, this is not a free pass to just lie or be sloppy. Now, to actually prove a publication was reasonable, media defendants can't just say, whoops. They are subjected to serious scrutiny by the courts, using a strict checklist of factors. They're going to ask, what was the nature and extent of the allegations? What was the overall tone of the article? Was it measured and fair or completely sensationalized? And most importantly, how reliable was the source? And what actual concrete steps did the journalist take to verify the information before they went to print? This standard brilliantly protects diligent journalists from the chilling effect, while firmly keeping negligent journalists accountable for harming someone's dignity.
Section 6. The final verdict. Striking the balance.
So where did the Constitutional Court land? They held that the existing common law, thanks to that vital Bogoshi precedent of reasonable publication, already strikes the proper constitutionally required balance. Because of this specific defense, publishers aren't trapped in a chilling effect, and plaintiffs aren't burdened with the virtually impossible task of proving a negative. Therefore, the Sunday World's attempt to force Halamisa to prove the statements were false was totally rejected. The common law is consistent with the Constitution, and the media's appeal was dismissed with costs. It's such a fascinating look at how the law has to constantly evolve to protect competing values. But I want to leave you with a thought as you consume your daily news. In an age of instant information and rapid-fire social media, where a single rumor can literally circle the globe in seconds, do you think this balance still holds up? Does the law protect your reputation enough, or does the threat of defamation still silence the truth? Think about that the next time you see a sensational headline. Thank you so much for joining me for this explainer, and as always, keep asking the tough questions.